The time is 6:50. It's June 6, 2016. This is the Hingham Zoning Board of Appeals. These proceedings are being recorded by the Zoning Board of Appeals staff and also by HCAM. The first item on our agenda is Riverstone LLC. This is a continuation hearing for a comprehensive permit under Massachusetts General Laws, Chapter 40B, Sections 20 through 23 as amended, to construct a 36-unit condominium development, including 9 affordable units, on approximately 6.7 acres of land located off Ward Street, map 124, lots 70 to 75 and 26, in Residence District B. So I think we need an update. Emily, we were talking about Riverstone. Is there anything in addition to the record that needs to be included?
We have the board's notice of safe harbor that was sent to DHCD following the last public hearing. It was dated May 12th. And then the applicant's notice to challenge the board's claim, which is dated May 20th. And other than that, no new materials.
Okay. Who's here for the applicant? Are there any new materials that you want to make sure are included in the record at this time? And if you just identify yourself for the record, please.
Yes, my name is Warren Baker. I represent Riverstone.
Just an update on the challenge. I spoke with Phil DiMartino from DHCD. They have received your documents and ours, and he stated that they are going to be responding in their statutory 30 days. No other information, nor would I have expected any.
Thank you. Any other documents you wanted to have included?
No submittals tonight, just to let you know that we have been working on a number of submittals, plan issues, and things like that, that when we have our next hearing, then we'll be able to submit and vet those.
Did you have a question for?
I had a question for Attorney Baker. When so I'm Susan Murphy. I'm Town's Real Estate Land Use Counsel. Did Phil DiMartino mention that? I know your letter was dated May 20th, but you sent it certified mail.
She's at the 21st.
They're doing it as of the 21st.
He said he noted that the receipt by them was the 21st.
Okay, thank
as
you.
My green card indicates too.
Okay, great.
We
thank
agree.
you.
Okay. That's it then. Thank you.
Thank you.
Susan, can you just review for us the dates and deadlines appropriate for this?
Sure. So that was the one piece of information I didn't have was the receipt by date from DHCD. So based on that, DHCD has 30 days, which would be June 20th is the last date that they can issue their determination based on the submittals. If they don't issue a determination by that deadline, then it's deemed in favor of the town. Assuming they do issue a determination, then either party who wishes to has 20 days from that date. So somewhere between June 20th and July 11th, depending on when they issue their letter, would be the outside interlocutory appeals of the Housing Appeals Committee.
Okay. And what about the suspension of these hearings? When would the rules require us?
Right now it's tolling, which means this period is adding on to our 180 days to complete the hearing. If an appeal is filed, that means there's a stay in place.
I'm sorry, if an appeal by the applicant or by the town?
Any appeal of the determination results in a stay of the proceedings until the interlocutory order is issued by the Housing Appeals Committee.
Okay. I know in the past we have stayed our proceedings during this initial period, even though it's not required.
Right. Yes. Yeah.
Because the time period has been extended. But I want to make sure
He's left.
I'm sorry?
Attorney Baker's left.
Oh. Well, whether or not he's left, these hearings are proceeding. So I want to make sure that if there are any members of the public who want to submit comments or questions for the record, I know if you are here, then you've spent the time to come here, so I want to afford you the courtesy of making sure that you're recognized. So is there anyone who is here for this application? Yes, ma'am. If you can just come up to the mic. Wait till you get to the mic and then we'll, if you just give us your name and address.
Eleanor Hickey, 5 Autumn Circle. The big question we have is submittal of information from the developer. We just wanted to know specifically when we should be expecting some of the information on the drainage analysis. I think he mentioned that he was going to be submitting that, I think, about a week ago or 2 weeks ago. So we just wanted to get a sense of that.
So, which is why I asked if there are any other documents available at this point. And I think the applicant expected that in light of the appeals we're having with DHCD, or it's not an appeal, in light of the issue that's being referred to DHCD, that time period for them to provide the information is likely going to be deferred. But we will certainly make sure that it's noted on the website, the town's website, so that you'll have ample opportunity, because this board is also interested in receiving that information. Thank you. Anyone else here for this application? Yes, sir.
Good afternoon. My name is Farouk Youssef.
Start again now that you're at the mic so that we got it.
My name is Farouk Youssef. I'm here on my behalf, my daughter Yvette Youssef, who lives in 48 Ward Street. And
Wasn't there a question about whether it was your house or your daughter's house?
That's still a
Are we
question.
going to resolve that this
But
evening?
I think we settled the issue here now, and she was inviting me again. So, last discussion when we talked, I mentioned that the application that he submitted was extremely insufficient.
Right.
He did not require, he did not comply with the requirement of
Yes.
760 CMR. Reading through the document he submitted, in the narrative he's saying, and I can just read one sentence here. It says the development area consists of wooded and grassed area. No mention of any ledge. In the eastern portion of the site, near the site bordering vegetated wetland. Of course, he's saying near the site, it is not within the site. And then he goes in and specifies the type of soil in that area as 3 types, which is Warwick, Sudbury, and Quonset. I looked at these 3 types of soil, and I was amazed to find, if you look at the Warwick, fine sandy loam, permeability, moderately rapid, depths of bedrock more than 5 feet, flooding and bonding none. You look at the other Sudbury, sandy loam, good drainage, and so on. You look at the Quonset type of soil, it's again very deep, excessively drained land, and goes on. It is the best site you can ever find. I just wondering, was he talking about the same area next to where I lived for 30 plus years? Or, I mean, you don't need to have somebody knowledgeable. You can bring any guy from the street, walk by, see the whole side of the hill ledge. None of that's mentioned. Not only that, I look at the drawing he has more than 40 test pits in the site. Is all of them the same? So my question to the board is, where all this engineering records? Is his engineers are protecting him? Or not? As a professional engineer or an architect, we are required to protect the health and safety and welfare of the public, not protect the health and safety and welfare of the applicant pocketbook.
Right. Well,
Yes,
right. So, I mean, that's an excellent question. This board is also concerned about the health, safety, and welfare
Correct.
Of the public, and we will make sure that the information that is required under the regulations are submitted. So I appreciate your comment, and I know this is not the first time you raised the question about insufficiency of information, and I expect it will not be the last from you, but also I think my fellow board members are also going to be...
I'm sorry to be
Right.
but again, as I'm saying, it's just something to bring up to your
Yes.
attention. Thank you.
Thank you. Yes, ma'am.
I am Kelly Collins. I live at 9 Autumn Circle. And I just had a question as far as logistics. So up until now, he has not been required to submit any of these timelines or like any more additional information as far as drainage and that kind of thing, all the things that Mr. Youssef is referring to. What's the point at which the town can say, you have not submitted X amount of details, and therefore your application is denied? Or when do we hold him to some sort of a standard as far as having to get that information in our hands as homeowners, abutters, that kind of thing?
Well, the board, on an ongoing basis, is going to be making inquiries to make sure that we have the information necessary to make an assessment. Ultimately, when we reach a conclusion about how to dispose of this, we will make a determination as to whether or not the information was sufficient. But we have made, the staff has made, and this board will continue to make inquiries to make sure that we get the information required under the regulations. Thank you. Okay, so with that, I know at the last meeting, we authorized the town's council to follow up on any response that the applicant would make in terms of challenging DHCD. Do we need any additional resolutions at this time to?
No. No, because you authorize council if there is a negative determination to file an appeal on the board's behalf.
And there's been no determination?
There's been no determination. It will come in sometime on or before July 11th. That appeal, assuming a negative determination, would have to be filed. So it's just up to the board whether or not you want to confer before July 11th.
We've got another hearing scheduled before then.
Right.
Next week, June 15th.
Right, yeah, so I think we're covered on that. Okay, so we need to then schedule the next hearing for this. The applicant's counsel is not here, so we're just going to have to schedule it on our own.
Well, I guess the question is, do you want to schedule something before July 11th so that the board knows? So council is authorized, based on your prior vote, to go forward with an appeal whether you meet or not. But whether or not there's a stay in the proceedings depends on the determination DHCD makes.
Right.
So do you want to schedule something before July 11th, just to say we have a negative determination or a positive determination, and based on that, there's a stay, there's not a stay. You know what I mean? Do you want to kind of just do another 15-minute check-in to say, based on what DHCD has said, this is how far out we're going to push this?
That's fine. Just for scheduling purposes, the 15-minute check-in may be the only business that evening. So if it may make sense, since it's not much time, just to wait until July 20th, which is a regular board meeting. It would only be another week out. So it would mean a week potentially of the hearing process would toll if it's an affirmative decision.
Right.
But presumably
So if we do the challenge, the hearing automatically tolls.
It's automatically stayed.
It's automatically stayed, right. So we cannot have a hearing.
Right.
Right.
After the 11th. So when is your next meeting? Just the 15th, and then
It's
not
just
again
next
until the
week, and not
20th?
again until the 20th, yeah. Could you schedule one with and then take no testimony in if it's been appealed?
Yeah, I mean, I think you could schedule it and then just continue it. Well, but then you need someone here to continue it, no matter what. So
Yeah, I think we should schedule a hearing, if for no other reason that to continue to hold the applicant's feet to the fire to make sure that the documents that we've requested, the information needed to complete the application is in, and they've got it on the record that we're continuing to make those requests.
Yep.
So what dates can we schedule?
Well, it sounds like we're not going to hear from DHCD until at least the 30th, right? Of June?
The 21st, right?
no, they have until the 20th,
June
which means
20th.
you can hear from them any time between now and the 20th.
Right.
I mean, if they were to, have a response next week, you'd only have 20 days from then. So, I mean, it's a little bit up in the air as to being able to pick up a fixed date in any event.
Right.
The agenda for June 15th is packed.
Right, so we've got a meeting already scheduled the 15th.
Right. Seven items on.
This would be a quick check-in, though, if we had to add it. It's just that it's so soon. It's only a week and a half from now.
I think we should
Yeah.
wait.
Okay.
Well, I mean, if you have a meeting on the 20th anyway, you can schedule for the 20th and just at that point say, if there's been an appeal, say in that it's been stayed, we're just going to continue it to a later date and not take in any testimony at that point.
Monday, the 20th?
That's Wednesday.
July 20th. So
Oh, I'm sorry, July 20th.
Wednesday, July 20th.
That works for me. Are you
That's good.
available? So that is going to be after when we hear from DHCD.
And after you've appealed, so it basically would be,
Then we can't have.
well, you can, you're scheduling it now, not knowing if there's going to be an appeal.
Right.
So at that point, it would be, you would open it, say, because this matter has been stayed due to an appeal, we're not going to take in any testimony and we're going to continue it beyond.
Right, but if one of our goals is to make sure that the applicant knows that we're looking for additional information, we cannot do it at that hearing.
That's true.
So we need to do it, have a hearing before then.
We could do it in writing, right? I mean,
Yeah,
at any point, staff can communicate with the...
Right, he can send in his information
He knows
before
what
it gets
information we
stayed.
want.
So then, yeah.
But I mean, we voted to appeal it, so.
Right, we are going to appeal. Okay, so I think that makes sense, and I'll just make sure, I'll follow up with the zoning administrator to make sure that we have an ongoing document request to the applicant to complete information that's required. So it's the, what do we say, the 20th?
Wednesday, the 20th of July.
So I'd accept a motion to continue this hearing to the 20th of July at 7 p.m.
So moved.
Seconded.
All in favor?
Aye.
Good, thank you. That's what you're...
You guys aren't sticking around for the rest of the fun now? I guess not. Guess not.
I thought Mario was here for the evening.
No, Robin's here.
Oh, where? Oh, I didn't even see her. Oh, okay. I really wish...
Just don't want to.
Yeah, I agree.
You might have turned it off already. They're trying to reduce the unit count?
No.
Okay.
No, not affordable. Okay.
Hello?
Hello. I'm well. How are you?
Fine. Right. Slab there for 10 years?
Have you been on the campus?
Oh, yeah.
Do you have friends
Yeah,
around?
my mother's still, my mother-in-law.
Oh, I didn't realize that. Okay.
Yeah, she's one of the first residents.
We're on the right.
Yeah.
Okay. Susan, did we get anything further or not? Did you have your phone call?
I did, but because he was literally pulling it with his client, he didn't have
Okay.
time to realize what he understands.
Okay.
the options are.
Okay, good.
Lyndon Hahn's team.
Yes. That's why I thought Mario should full circle.
I don't think he wants to.
Okay. The next item on our agenda is Hingham Campus LLC for a notice of project change pursuant to 760 CMR 560511 to a Linden Ponds comprehensive permit to reduce the approved number of units from 120 to 104, along with related design and site plan modifications at 301 to 303 Linden Ponds Way, building RB 2.5. And who is here for the applicant?
Good evening, all. Ting Chance from Novus Engineering. And here with me also our Councilor Great Petersons, Day Archibald from Arison's Livings, and Linden Ponds applicant as well.
What was your first name?
Ting.
Ting?
Yep,
We will give you a couple minutes to continue your setup.
that would be great. Thank you. Excuse me, microphone isn't working.
This one's not working? Sorry.
Well, it's actually for cable TV, so.
Oh, it's working, it's not from the PA. So do people maybe speak up because their backs to us?
Okay. How you been?
Not too bad. How are you?
Good.
Thank you. Can anybody hear me at all?
Yeah, but you'll need
We had
to
a
speak up.
request to speak up because that mic's not amplifying.
Oh, okay. Okay, all right then. We're here to seek insubstantial changes to the comprehensive permits of the Linden Ponds for RB 2.5 buildings. This RB 2.5 was part of the original's comprehensive permit. We are seeking insubstantial change because we're changing 120 units to 104. We basically, it's a very insignificant change. We're changing the bedroom from 195 to 176. There, in terms of floor areas and the building footprints, there's no changes to it. The impervious areas, it's about 0.03% less than what was proposed before. Elevation-wise, there's no changes, remain as 7-story. Building height, same. Color is the same as, will be same as RB 2.3 and RB 2.4, similar color schemes. Wetlands, setback remain unchanged. Affordable units percentage is 27.7 from the original 1,750 total units count. In terms of site design, we are looking at 108 parking space, which is already existing at the site currently. We are proposing a overlaid and portion of it being reconstructed because of the grade issues. Drainage-wise, we are doing, it's part of the original design. We are changing. One second. Flip this over for a second. There we go. Oops. All right, here we go. All right, here we go. Drainage-wise, this is part of the original designs. All the infrastructures are in place. We have drainage system stub out to collect the front ends and the north face of the building roof drains along with the parking lots. In the back, we'll have a perforated pipes to collect east face of the building roof and then discharge out in the roof. This is exactly what was proposed previously. Utilities, we have stub out for sewer that we're going to bring into the building at 2 different places, as well as the water main systems. Electrical, there's already a transformer pads in place, conduits already in. We'll bring it in straight into the building. Gas and telecommunication were coming from the community buildings, connecting. It's a very minor changes and minor construction-wise in terms of site designs. We're putting up the buildings, and that's pretty much the scope of the design.
So if I could summarize, it's pretty much the same as it was, just fewer units inside the building?
Absolutely.
Because I know that pad's been there for 12 years?
Yes.
13 years?
Yes.
It's been there for a while. Been there when I was working on the project, which was 12, 13 years.
The original was 2001.
Right. Correct.
Built.
Which was neighborhood 1, right?
Neighborhood 1.
Yeah.
This is the last piece of neighborhood 2
Yep.
that we're finishing.
And neighborhood 3, who knows? So, right.
Right here.
I call that the moonscape. So.
So the connection to the dining hall is
It's right here.
And eventually, if neighborhood 3 gets built, there's a
There is a
connection
future
down at this,
connection bridge that will be connecting. There is a
that goes
foundation
over what
that
we used to
we're
call the
putting
Grand
in.
Canyon. Yeah.
We are planning to put in the footing for the pedestrian bridge at this point.
Yep.
So, any other questions?
I think that's a good explanation. Did you, Robin, do you have any questions?
As you can tell, I'm very familiar with the project and the site, so
Right. One of the concerns that I have, it's not to do with the structure, but it's the impact on affordability. And this is, I'm sure your counsel can assist me on this. How will what's being proposed affect the number of affordable units being recognized for the project?
So my name is Greg Peterson.
You might want to raise the mic.
Just see if what if I just tilt it that way? Does that, okay. So Greg Peterson, and am I pegging your meter there? Okay, good. I was in radio once upon a time. I've been told I have a face for it. So on affordability, basically the point is to have no change at all, right? This board, the previous history of the approvals here calls for a minimum of 27.7% of the units at Linden Ponds to be affordable. There's a state minimum of 25% under the 40B program. This is at 27.7%. In terms of
27.5 or 27.7?
27.7.
0.7, okay.
27.7 in terms of the minimum that we have to meet under the comprehensive permit as it's been adopted and previously amended by this board. The last series of conversations this board had and others had about this was in 2013 and 2014 when there was the first round of conversations about the fact that two-bedroom units are more desirable than one-bedroom units, and so that it was a desire to have more two-bedroom units and consolidate the number down. But at the same time, there was a firm commitment on the part of Erickson to have the 27.7% affordability requirement be keyed off of the original approvals for the property. So in the submittals, and I apologize if we were insufficiently clear in the letter or in the tables that we submitted to the board, but let me be crystal clear right now that as far as we're concerned, the calculation of the 27.7% of the units required to be affordable in neighborhoods 1 and 2, and if it were ever to happen, 3, are going to be based on the total number of originally approved units. So in the case of neighborhoods 1 and 2, that original approval number of units is 1,108. In other words, if you apply 27.7% against that, that's at least 307 units must be affordable at all times. At this point, with this request for this proposed insubstantial modification, the number of units in neighborhoods 1 and 2 would drop down to 1,071 versus the 1,108 originally contemplated for neighborhoods 1 and 2. But we would hold to the 27.7% of the original 1,108. I would also note that CHAPA today has filed its report on Linden Ponds, and this was addressed to you, but Lord only knows if it made its way here.
No, we haven't seen
naturally, of course not. But they, reading from this, I see that CHAPA says that there are 314 current units that in 8 buildings with 955 occupied units that they have certified as income eligible. In other words, folks who meet the affordability requirements on income. And as a result, 32% of the residents have been certified as income eligible. So 27.7 required, and currently we're meeting that with 32%.
And that's outstanding. The challenge that the town faces is that DHCD has been calculating the number of affordable units in our SHI based on a 25% of the number of units. So as you decrease the number of units, no matter how many you maintain as affordable, the result to the town is a lower count of affordable units. And I'm wondering how you can help us address that, because I understand that you're maintaining the number of units, but the impact on the town is a negative impact. We are now losing, because of what's being proposed, we are losing affordable units in our housing count, according to DHCD. So
the critical words in that being according to DHCD.
Yes.
Right. So I've had conversations with my client about this, and as far as they're concerned, the 27.7% is in the permit. The obligation to have that 27.7% apply against the original permitted amount is in the official permit as it has been modified over time. Yeah. So to the extent we've got a problem, here collectively with DHCD, perhaps it's a reading comprehension issue. I don't know. Maybe they weren't doing the MCAS, early enough to, well.
Well, I think, in all fairness, they have their view of what is required. I think we have our view, and I think we share the view with you. And what I would hope is that as we move forward, we can count on Linden Ponds to be joining us in explaining to DHCD, in fact, that the affordable units that you are providing are, in fact, significantly greater than simply multiplying 25% times the number of units. Right. This board has taken the view that, in fact, the entire project should be viewed as affordable because of its rental, not ownership. Right. Putting that issue to the side and saying, well, maybe they treat it as ownership, it would still be at least the 27.5%, and greater, given what you've got, which is over 32%. Not simply a 25% times the number of units. Because again, as you reduce the number of units for your own economic reasons, the impact on the town in terms of our housing count is negative. And so that is the material, and it's materially negative to this town, and we'd like to be able to count on you to be an ally in making sure that DHCD agrees with the positions that you and I have both espoused.
But we can certainly state the facts to DHCD, and I don't think we have any issue stating the facts. If you're looking for a letter from us, obviously we'd have to run the text of a letter by our board, whatever it is. But speaking at a level of generality, from our perspective, the permit says what it says. It says 27.7% of the original number of units. That's what we have to do, or we're out of compliance with the permit. And you would pull our certificate of occupancy, and where would a whole bunch of, senior citizens be? In a very bad place, right? So we're prepared to state those facts and our, plain reading of the documents, if that's at all helpful. Beyond that, I'm not quite sure what else you might be asking for.
Well, I think rather than having you author something, it would be that we would be authoring something and basically running it by you and having you say, yes, me too.
Yeah. I think that makes sense.
Yeah. And that, I think, would be helpful. So DHCD is clear that it's not this board coming up with a view, it's actually what the applicant views the permit as requiring. And that would be very helpful. What we did last time in 2014, we issued the decision. We actually went through a hearing and issued conditions. And I understand that you actually are incorporating those conditions into your requests so that we don't have to say it's material and then do the full hearing. If you incorporate those conditions in what you've requested as the project change, then we can view that in its entirety. Right. If it comes from you, we can go that route. If it comes from us, I understand we cannot impose conditions in this hearing because it's simply whether or not it's materially a substantial change or not.
Right.
And if it's not substantial, that's the end of the discussion. So we would need part of your description of the project change to include the conditions which would allow us to say, yes, it's not substantial. But if it's not part of the project description, we can't add it. We can't by resolution saying, you know, we move X, Y, and Z. It has to be part of the project description.
Well, would you be willing to accept such a written statement from me? I mean, and I've shared this with your counsel earlier today. I've reviewed this with my, you know, with my client, and
right.
You know, they're, you know, to be clear about it, I'll just read the language, okay, into the record or onto the tape recorder here. The affordability requirements for units at RB 2.5 under the proposed modification, which is the application before you, will remain unchanged from that previously approved by the board, including without limitation the requirements set forth as conditions, paren, conditions 1, 2, 3, and 4, being all of the conditions, close paren, in the decision of the board dated June 30, 2014, which was treated as a substantial modification and was the subject of formal notice and public hearing. The applicant, Hingham Campus LLC, has recommitted to these arrangements and undertakings, both in open public, you know, meeting before the board and in the application, including the cover letter and summary table 3, at least in the way we read the application letter and summary table 3. See especially footnotes 2 and 3 and the related table sections in summary table 3. For an abundance of clarity and specificity on this point, the calculation of the 27.7% of the units that are required to be affordable units in neighborhood 1+2 of the Linden Ponds project shall continue to be based on the total number of originally approved units for neighborhoods 1 and 2, being 1,108 units, e.g., at least 307 units shall be affordable units, close paren, rather than 27.7% of the total cumulatively consolidated unit count for neighborhoods 1 and 2, paren through the proposed modification, you know, requested here of close paren of 1,071 units. So, yes, Jim?
Yeah, right.
Yes,
okay,
Christie?
so
Okay.
what I'd like to do, because I have the decision, and the decision that we did in 2014 related to a combination of units. In this case, we're not actually combining units because they haven't been built yet. You're building new units according to different specs. So what I'd like to do is...
Albeit you're combining approved units.
Correct. Okay, so what I'd like to do is review the decision that we made and ask you if it's consistent with your project description.
Okay.
So we can have it on the record. So whereas before the condition, it said the combination of 36 units as approved herein, so I'm just going to say that the number of units proposed by the applicant at these hearings shall not affect the total number of affordable units required in the project as specified in the comprehensive permit dated September 18th, 2001, or any other conditions of the comprehensive permit. The calculation of the 27.7% of the units that are required to be affordable units shall be based upon the total number of units occupied in order that there be no decrease in under the original plan, so in order that there be no decrease in the total number of affordable units as a result of the proposed modification. So if
listening to that carefully as I could, my question would be, do you mean to say occupied or do you mean to say originally permitted?
Yeah, because
should be.
you take out the plus 12.
Yeah, you're right. It's got to be originally, right. So we need it to be originally permitted. You got it.
Yeah. Okay.
So is that acceptable? Is that part of your project description?
Yes.
Okay.
Yes.
The next point is that the project as proposed, your proposed modification will not affect any other affordable housing components of the comprehensive permit, including without limitation the total dollar amount of the scholarship fund as determined under the original comprehensive permit.
Correct.
Okay. And it's also part of your project description that a determination by DHCD or any successor charged with maintenance of the SHI to reduce or remove units within the project from qualification for the SHI shall be deemed a substantive change of the project and a material violation of the comprehensive permit. So that's verbatim what was in before.
That's verbatim what was in there before, and part of the reason I'm uncomprehending of DHCD's position.
So, but that is part of your project description at this point? Okay, and then finally, that approval, that you are agreeing that part of your project description means that if this board approves the project as modified, it will not constitute a waiver of, nor shall it be deemed an admission or evidence contrary to the town of Hingham's stated position that all units at the project qualify for inclusion on the town's subsidized housing inventory.
Before you respond, if you wouldn't mind, could I just suggest a couple of wording change? So this is not under the regulations and approval. It's a determination that this change is unsubstantial.
Correct.
So I would revise that to number 4 to say, determination that this change is insubstantial shall not constitute a waiver.
Right. So I'll just read it. So a determination that your project modification is insubstantial will not constitute a waiver of, nor shall it be deemed an admission or evidence contrary to the town of Hingham's stated position that all units at the project qualify for inclusion on the town's subsidized housing inventory.
Yes.
Okay, so that is now part of your project description, and now it's up to the board to decide whether or not we view that as a substantial or insubstantial change.
And did you want to add a number 5 per the discussion tonight about the cooperation?
I'm sorry, yes.
Yes. Okay, so that
do you have
would
some
be-
language that you could suggest for that?
Did you we were kind of bouncing it around on the
No, I was
telephone.
following the chair's lead in saying that you guys would send us something and then we would look at it and
Why don't we
review it
say-
and say, and, you know, but make sure it like read right and then, you know, say, yeah, exactly, what that says.
So the language would be something like part of the project description would be your project modification would be the applicant's commitment to join with the board and or the town of Hingham in its communications with DHCD concerning the affordability of units at Linden Ponds. Is that adequate, Susan?
Emily, can you read that?
Could we say stating the applicant's understanding of the requirements of the comprehensive permit with respect to affordability at the project?
Okay, let's start it all over if you could,
Well,
Emily.
what Joe started with was part of the project change involves the applicant's commitment to join with the board and/or the town in communicating to DHCD, and I lost you there.
Okay, in stating to DHCD the affordability requirements of the comprehensive permit as understood by the town and by the applicant.
Yes.
The affordability requirements of the permit as understood by the board or the town? The town?
And the-
It's really the
Yeah.
board
Yep,
and the applicant.
and the applicant.
And how about, and as further modified by the annual independent verification by Citizens
And,
Housing?
yeah, and as certified by CHAPA?
And is certified by CHAPA.
Right.
Well, that's,
CHAPA certification is CHAPA certification.
Right,
It
I'm
speaks
not-
for itself.
Yeah,
I think the issue here is
Yeah.
a common reading that we all have of the comprehensive
Right.
permit documents that DHCD, for
Right, and
whatever
actually-
reason, doesn't seem to
right,
share.
and CHAPA's documents are actually part of the comprehensive permit. It's the monitoring program. Yeah.
But if it's 30%, they should recognize 30%.
Oh, right, but that-
27.7.
Right. but
Yeah,
I think that's, any other change to that, or you?
no.
Okay. Okay, so,
Questions for me?
no, so that's
May I
all.
sit down?
Not yet. So
Yeah.
those, wait.
I'm going to tweak your number 1 if that's okay.
Okay, but what we're talking about is now 5 points that are part of your project description that we will now say either is substantial or insubstantial. Yes,
That's
I'm
fine.
sorry. Susan, go ahead.
So I believe you stated for the first one that the number of units proposed by the applicant at this hearing, or something to that effect. Again, this isn't a hearing.
Right.
So I was going to suggest that it say the number of units proposed by the applicant as part of
In
the,
its notice of project change.
As part of its review of the proposed notice of project change.
as part of the, well, no, so the number of units proposed by the applicant
In its,
as
Number
part
of units
this-
proposed by the applicant in RB 2.5 in its application for an insubstantial modification to the comprehensive permit
Thank you.
is
In
104 units versus
No,
120.
No, we don't want
An
to,
insubstantial change. It's just a notice
no,
of
project change.
Yeah.
The number of units proposed by the applicant in RB 2.5, I'm sorry, what were you going to say?
In its notice of project change.
In its notice of project change. And then, shall not affect the total number of affordable units.
Right.
Okay,
Good.
all right. Now they're all clean.
okay. Joe, any other questions on this? Nope. Robin?
I have none.
Is anyone here for the project? Yes, sir, if you don't mind just coming up to the mic.
Jim Watson, 291 Rockland Street. Is that loud enough?
People behind you can't hear.
I'm sorry. Jim Watson, 291 Rockland Street. Member of the Housing Authority, but speaking just for myself. Two questions. One, just a design question. I'm puzzled. I understand the idea of making fewer, bigger units with the 2 bedrooms, but the reduction in bedrooms would seem to mean that the reduced units aren't all 2 bedrooms, they're just bigger? Fewer but bigger in summer 2s?
So is the average size of a bedroom increasing? Yes. Yes, that's exactly right.
So it's not, that's why they aren't all 2 bedroom, because they're bigger.
They're bigger.
Right. Yep.
Right.
Sorry, but I didn't get that. So why is the change? Like, what does it mean?
So we're going to let the person speaking continue, and then if you want to talk afterwards, that'd be fine. Okay.
Yeah, we just report. The more basic question is, I'm very puzzled about the degree of affordability, because I haven't heard. I followed the succession of decisions some time ago. I remember the 27% was the number of people in the project who were presently low income, having paid their deposit. So that I gather, but I'm asking, can a person who makes under 80% of the median, the usual standard, knock on the door, apply with no other resources than a moderate income? I mean, has the scholarship fund been used to totally waive the deposit in many cases, or just to shave, to reduce it a bit? I'm just puzzled because it isn't quite what we understand as affordability, in other programs.
So first, the 27.5% is not the actual number, 27.7%. That's the minimum required in the permit. The actual number is higher in terms of the number of people who meet the affordability standards.
And their present situation. What I mean is that they came up with $200,000 plus or minus deposit, and then they were low income. Or were they low income like people applying to the Housing Authority and people applying to Lincoln Apartments and so forth, who have to be below 80% of the median, have to have enough to cover the rent, but don't have to make a very major deposit. And that's what I think is quite different.
Susan, do you want to?
Was that clear to anybody?
Excuse me, so Jim, your question is about making and I just want to make sure I refer to it correctly. What is that called? The deposit?
Entrance deposit.
The entrance deposit. The entrance deposit. So, my understanding, but I'll let the applicant correct me if I'm wrong, is that there is an entrance deposit for all the units. However, there is a scholarship in place, that's still in place, and in fact, the CHAPA certification speaks to it.
$5.7 million originally.
Right, and the CHAPA certification, which you can get a copy of, speaks to it, and so that if people don't have sufficient assets for the entrance deposit, the scholarship makes up the difference.
What I'm wondering is...
That's correct, is that correct? Yes.
And then there's also the income question that you
Yes, and the income also applies, so they must also be income eligible.
So has it made up the difference to the extent of actually waiving the whole deposit so that a person who could apply someplace else can apply with you? I thought DHCD said you should, look at them income neutral. And it sounds, I'm asking, it sounds as though the bulk of the deposit is still required, because the 5.7 wouldn't cover waiving a great many deposits.
So the scholarship award, the scholarship amount is to make up the difference where they don't meet the threshold for the entrance deposit. So that just makes it, no one has gotten a full and complete.
Has nobody asked for it, or is nobody?
No one has been in need of that, in terms of coming in and needing a full scholarship for the entrance deposit because of the requirements that are needed for our income.
So that is presumably possible, but hasn't happened. That a person would-
I guess that maybe, just so we're clear, what we've been talking about, there is no change in the financing issue in terms of, so part of what you're asking is not part of what we're here for?
No, I realize that.
Right, okay.
I'm just
So if
saying-
you'd like to have a discussion outside of this hearing with Linden Ponds about funding for scholarships, that's great, but that is really not part of...
I was just concerned because I think people watching the program are going to think, gee, they're affordable, just like all the other affordable 40Bs. And it isn't just like all the other 40Bs.
Well, I mean, it qualifies as a 40B project, and there are different eligibility requirements for each project. I don't think we're going to try to go through each eligibility criteria other than to encourage them to contact Linden Ponds directly if they want to apply or if they've got questions.
No, I remember when the state gave them the letter saying, be income neutral, publicize the scholarship to everybody in every ad, and so forth, which hasn't always happened. Okay, thanks.
I'm sorry, just explain what the change is.
The only change, if you want to ask a question, come on up to the mic and you...
I don't want to come to the mic right now.
Then we'll continue. Any other questions? Would you like to ask a question?
No, I'll ask them outside.
Okay. Okay.
I can ask it for if you want, and I'll stay on the point.
So then, I guess the only question before us is whether or not the proposed change is substantial or not. And the criteria, Susan, typically is a 10% criteria. Do you want to walk us through it?
Yeah, so the 56.0511A states that within 20 days, which the board is within 20 days of the application, the notice of the project change, the board shall determine and notify the applicant whether it deems the change substantial or insubstantial with reference to the factors set forth in 760 CMR 56.074. And those changes, and Emily, I believe the ones that we're looking at are the following matters generally will not be substantial. So these are just examples of circumstances that ordinarily will or will not. It's not a kind of a mandated, but it's examples. So the following matters generally will not be substantial changes: a reduction in the number of housing units proposed, a decrease of, or in this case it would be, yes, an increase of more than 10% of the units would be substantial. A reduction in the size, I guess I'm not, Emily, which ones are we?
You enter D. Sorry.
Oh, so D. A reduction in the number of housing units proposed. A change in the number of bedrooms within individual units if such changes do not alter the overall bedroom count by more than 10%. And I think that those are the only two. Is it the change in the number of units, a decrease in the number of units, a reduction in the number of units, and a change in the number of bedrooms that do not alter the overall bedroom count by more than 10%.
Right. So what they proposed would not meet any of these thresholds.
One of the issues that we looked at in 2014 was sort of doing this by increments, that it might trigger it if it was all at once by doing some in 1 year, some 3 months later or 6 months later, that the board is concerned and wants to make sure that we look at it in its totality. But even in its totality, I don't think we're reaching a substantial issue here, at least as it's been presented, but of course we would reserve our rights depending upon what happens going forward. And particularly given the project description as made very clear by the applicant and its counsel here. I'm comfortable that this is not a substantial change. Robin, what's your?
I agree.
I agree as well.
Okay.
It's going to look pretty much the same as what was originally approved, so.
Yep. And there is no change at all in the issue of eligibility in terms of affordability.
So is that a motion that the board make a determination that based on the project details of the applicant that it is an insubstantial change? Is that the motion?
So the motion is based upon the representations and submissions made by the applicant. I would accept the motion that the proposed project change is not substantial.
So moved.
All in favor?
Aye.
Done.
Thank you.
Thank you. Thank you. Do we have anything on our agenda else here before we...
Before we go next door, can I just check in on their...
Yes.
Maybe we'll be able to tick off something.
Planning board already did this.
We've already withdrawn, so we don't even need to.
Oh, thank you. Good.
You're on.
Were you here last week or 2 weeks ago?
We got here.
I haven't either.
This was the deadline today, right?
Good night, everybody.
Thank you, Susan. I know. Thank you. Thank you very much. Thank you. You out of here soon?
That was interesting. The attorney for Riverside.
Thanks. This is the, well, you're right, that's going to be,
Planning board just voted to withdraw the open market Derby Street application. They have already started the Lincoln Street application. I think they're going to focus on parking if we wanted to do Derby Street, or...
I think we should do Derby Street,
Right.
so we can get that handled.
Yep.
Okay. Next item on our agenda, WSM Hingham Properties LLC. This is a continuation hearing for modification of the existing Derby Street Shops Special Permit A2 under Section 3A, 4.17 of the zoning bylaw, and such other relief as necessary to modify, 1, convert 2 retail spaces to a financial use consisting of a Capital One cafe, and 2, operate a seasonal open market on Fridays within the parking area near the Coles Building at 90 Derby Street in the Industrial Park and South Hingham Development Overlay District. Mr. Devon, are you here for the applicant?
Robert Devon, Andrew Manning, Bill Harris. When we were last here, or up through the last time we were here.
Yeah, if you can go to the mic.
You can sit up there, Bo, if you want.
If you're more comfortable sitting, you could sit there if you'd like. Okay.
Prior to tonight,
Yes.
the board has voted but not yet issued its decision on the reduction in the parking spaces in the vicinities of Burton and Apple.
Yes.
The board considered Capital One and asked that we come back with some perspectives from the sidewalk as to what it would look like.
Yes.
We have pending a request for a withdrawal without prejudice of the open market portion of the application.
Okay. Do we have that request in writing?
Oh, yes, you do.
Got it.
It's in here somewhere.
Okay. So, do you want to...
That's the easiest part of them.
Easiest part. Do you want to walk us through Capital One?
Andrew?
For the record, Andrew Manning, WS Development and WSM Hingham Properties, LLC. I'm not sure if you want me to speak with the microphone in front of the... Oh, that's fine. Enough? Yeah.
I'll let you know if that's on.
Yes? Okay, so we began to look at this plan, but we only had 11 by 17, so I thought it would be a good idea. Let's start with this, blow it up, show you what's going on. So again, Capital One Cafe, very different type of financial use. We've gone all through that. So again, this column line A is the front of the store. That's what you would see today. Right now, one half of this is a space, and the other half wraps the corner as a space. In combining the two spaces, just to put it in perspective, this column line B1, that's the front of Lululemon today, okay? And then this is the front of the rest of the shopping center.
And to make clear what you probably think is obvious, show us the windows from the outside.
Right, so this is the main door that's proposed. There's glazing here. There's glazing on these two corners all the way back to Lululemon. The other piece that's very clear is in here, in this corner, those are fully operable windows. They slide all the way open. So you physically could walk on a nice day like tonight. If they open the windows, it would feel like you're on the patio. It would just be you're in an enclosed space. And so the area that we've highlighted here in this tan floor, that's really the cafe piece. So that goes all the way back to column line C. More depth than you actually see in the front of the space, right? And so here's your kind of Pete's Cafe area. There's seating tables in here that we don't show on this plan. This is the condiment station where you would get your creams and your sugars and your trash and whatnot. And then this is a benchtop type seating area. And so where would you see the banking services? One piece that we talked about. This is 2 ATMs inside of a secure vestibule. So after hours, insert your card, enter the vestibule, but you can't get into the space. These ATMs face inside, meaning towards the space. They don't face the glazing. They face in, right? And so these are where the windows would be. So really, as you're walking by, you might get a glancing view of the side of them, but you're not seeing the ATM screen in the storefront. And then everything to the back here is what I would call your traditional banking operation, meaning multifunction space, office areas, a meeting room, common bathrooms. Again, people from here would be coming into the back to use the common bathrooms. That's the bathrooms for the facility. And then you have back of house office and egress doors and whatnot. So with that in mind, I mean, yeah, it's 50-50 when you look at it this way in space. But the real take-home point is really, you know, when you're looking into this space, you've got to look in almost as far as you see sticking out to actually start to see banking functions in the back. And so what we've done is with our architect who designed the storefront for this space, we've been working with a rendering. And again, this is a rendering superimposed on the image of what you would see there today. So again, Lulu storefront, new facade treatment. We did something else that's interesting in that this is the doorway area. And so within that doorway area, we've actually broken up the facade to make it look like two smaller storefronts. And really where you can highlight the cafe seating, all of these doors right here in this front corner, those all slide wide open. Right, so 3 of the windows would slide all the way to the back where Lululemon is. 2 would slide into the corner so that there would be a free flow area in there. You can kind of see in the background where the menu board would be behind the cafe. You see seating in here. This area in this corner, you know, that's where you'd see the wall that the ATMs are built into. It would just be a blank wall. It's not anything going on, but it's the area where you would hide that ATM equipment and where you'd have a service in the back. And so as you look in, pendant lighting, rooftop, you know, very nice architecturally, you know, designed roofing within the cafe area. So when we see this, you know, we think of it as the cafe being the storefront. We want it to be active. We want it to be part of the shopping center in a focal point and a gathering point for the center. And I think the combination of everything would be a great addition to Derby Street Shops.
So I think I know the answer to this question already, but the cafe is open to any and all customers who are coming in, not just customers of Capital One who are doing banking, correct?
You can go have a meeting there with friends after work, or earlier in the day if you want to grab a cup of coffee together, go in, coffee, and leave.
What do you charge for the coffee?
I don't charge anything. But when the menu board goes up, I'll let you know.
And it's going to be, so Pete's Coffee is going to be...
There'll be logos,
prominently
right.
displayed on the front.
So what we do is, we also have, as you know, a very prominent sign criteria that we have to follow. And so part of this is also working out what parts are we going to promote as the cafe piece. Whether it's actually up above, we are limited a little bit in how big the signage can be, so it may be in the glazing of the windows, but I will guarantee you that there will be Pete's signage for the cafe. There'll be cafe signage, so that as you're walking down the sidewalk, you know it's not just Capital One, but there's something else inside.
Right, so people will know that if they want to get a cup of coffee and they don't want to discuss their 401k, they can do that.
Absolutely. And that's how it'll be promoted by our staff and in the store management staff as well.
I don't see signage on here.
So signage is a tough one because we have a very specific sign criteria, and so we're working with them to figure out exactly what it is. It's going to be a Capital One sign. It's going to be a Cafe and Pete's sign. We're trying to work with them as to the best locations to accomplish what you're looking for, which is activate the cafe side. They're going through a sign program right now that fits within the criteria, again, which is either top lit or halo lit signage. It isn't their prototypical signage, so they're spending some time going through that process, and we're working with them. If you have thoughts or ideas, I'm more than willing to look at it. I'd love to have Cafe and Pete's on the corner, and that's what we'd like to activate. And, one thought is, one of our thoughts is to where you have the ATM and the bank, limit the Capital One sign onto that side. It's a little bit of a balancing act between tenant, landlord, and the town. But that was our initial thought, and we're going through that. We have to come back to the town for a sign permit as well, which again goes through the review, the design approval process, and whatnot. So we're definitely looking at it, and it's not shown because there's not a clear answer right now as to where signs would go.
Correct me if I'm wrong, Robin, but my understanding of one of your requests is to make sure that the signage is clear so that the intended use as a cafe is appropriately promoted. And I'm a little concerned because if Robin's approval is conditioned on that appropriate signage and you don't have the signage here, how is it that you're looking for us to say this is appropriate without giving us the visual cues as to how to make sure the communication happens to the visitors at the Derby Street shops?
So the hard part is we have a tenant that's a Capital One bank, and their primary signage under our guidance obviously needs to be Capital One. That's the tenant who's paying. It can't be Pete's Coffee Shop.
Sure.
So now we get into the issue of our sign criteria only allows for one sign for the primary tenant. So all of the other signs need to be in that secondary category. We envision that either on one of these neutral piers, we would have a blade sign that would have Pete's Coffee on it, so you would clearly see that. We would also see some in these upper story windows some secondary signage that says Cafe and Pete's Coffee and whatnot. But we need to go work through the areas to make sure they fit within the sign criteria. If the board, wishes to have a conditional approval that you approve the sign look, the use is acceptable with an approved sign, I don't see why we wouldn't come back and certainly show you the sign and say, here's how we calculated the sign areas based on the criteria to make all parties work with it.
Emily, have we had an issue with other locations at Derby Street in terms of internal signs, like in the windows, pasted in the windows, that are sort of becoming auxiliary signs? We just want to make sure that...
We have a very strict criteria as to what is outlined and allowable.
Okay, right.
Like, we have to have a store number in the window. We can allow one blade sign of a certain size. So our criteria is very...
Just going back to the plan that you had on the other side there, the area that's in gray in the back, is that all, are customers going into that area?
Yep.
Or is that kind of for internal?
Nope, customers go into that area. It's part of the banking side of it. I just differentiated the colors so that it was clear. But this is, this area right here is storage, but here's your restrooms.
Yep.
Here's a meeting room, a meeting room, a meeting room. And then once you go through this door into this hallway and back here, that's the back of house.
Okay, that's the traditional banking area in the back, though, but the cafe will be used also.
Yes, as part of banking with mobile apps and discussions, absolutely. So the back, less than quarter, is a no customer area. Egress door, etc.
Good. Yeah. It's a departure from the other look and feel of the storefront.
It's a little bit of a departure in that I can describe it. So this is a white stained cedar. So it's a material that actually still blends in with a lot of the clapboard look and feel, but being a prominent corner, we wanted to make it feel like a prominent corner in a meeting point, in a gathering point, so when somebody says, that's the corner, it gives you the feel. But it also breaks up the storefront from, I think, what you'll see today is a lot of repetition in the storefront. This tries to break that up in depth and material, and then bring in the operable windows. If you're out there today, Company C has an elevated window, but it doesn't wrap the corner. We brought that around the corner to really create that airy space in that prominent area, so you see into it a lot more.
Are these tables that are outside part of the cafe? Or
no, we have, as the landlord in the common areas, we have a number of tables around. Right now, there's a lot of tables you'll know down by Whole Foods Market and in various areas. So we envision a couple common area tables that would assist and activate that corner and make it more pedestrian friendly.
Well, I mean, since I was the one who asked for this, I suppose I should speak. I mean, I'm satisfied. I think the rendering is very inviting. It looks nice. I think it, I mean, I don't know, from my perspective, I think it's, it looks inviting. I like it. It does blend with the Derby Street shops in a way that I had hoped that it would. So,
great.
And I like it that you can see the cafe inside, and it looks like a cafe through the windows. It doesn't look like a bank, which I think was my initial concern. And to the extent that, you know, anybody can go there and get a coffee, I think that's great. So
absolutely.
I'm satisfied. I think that the suggestion that the sign be a condition of the approval is appropriate. Yep.
I would agree. I'm looking to see if there could possibly be anyone else who wanted to comment, except the gentleman from HCAM. Do you have any comments? No.
Does not.
So then at this point, there are two motions that I would entertain. The first one would be to grant the applicant's request to withdraw without prejudice the portion of its application concerning the proposed open market.
So moved.
Is there a second?
I will second that.
All in favor?
Aye.
And withdrawn without prejudice. The second would be to accept the applicant's, no, this is going to be, do we have to go through the special permit criteria, Emily, for this, or?
Well, I mean, to the extent that it's just a modification of the existing, if you find.
Yeah, I think we did that.
I think we did.
I think we did. Yeah.
So then it would just be to accept the applicant's proposal to convert the designated retail space to a financial use consisting of a Capital One cafe, consistent with the representations and presentations submitted to the board, and conditioned upon the applicant submitting a signage proposal that's acceptable to the board for this space. And I guess the third would be that nothing herein should be viewed as as granting any modification to allow any other financial use of space at this project. Thank you.
So moved?
So seconded.
All in favor?
Aye.
Thank you very much for
Thank
your
you.
presentation. We have one other issue. Apple has been told by the building inspector.
Mike.
No, sorry.
Apple has been told by the building inspector that they will not get a certificate of occupancy until the sidewalk work and the removal of the 2 spaces has been done. You have not written...
Built this?
No.
Oh, there it is.
The one down by Apple.
Right, okay.
You have not yet issued your decision on that, although you voted to approve it. We would like, in order to accommodate Apple's schedule, to go ahead and begin the work at our own risk, okay, understanding that, what all that means. And we just want your blessing to do that.
Well, if it's at your own risk, then you don't have our blessing.
Well, but at least acknowledge that you are aware we're going to do it.
We are aware that you're going to do it, and you are clearly proceeding at your own risk, and we will move as expeditiously as we can to fulfill our obligation.
Thank you very much. Right. That's it.
Thank you. Okay, so with that, you think we're ready to go next door? So I would accept a motion that we temporarily adjourn this meeting to reconvene in a joint session with the planning board.
And I will temporarily move.
I will temporarily second that.
All in favor?
Aye.
We are temporarily adjourned.